You're watching the legal breakdown. So, Glenn, we've got some quick movement here by the Supreme Court. Yesterday, Trump requested a stay from the Supreme Court on sending the immunity issue back to the trial court. And already today, SCOTUS is taking action. So, what happened here?
Yeah, Brian, the Supreme Court just lit a very short fuse, and I think it's ultimately a good sign. So here's what happened. Yesterday, Donald Trump, at the last minute, filed a request to stay or stop his trial from moving forward in the trial court. This, of course, is the federal prosecution in Washington, D.C., being presided over by Judge Chutkan for Donald Trump's attempt to overturn the 2020 presidential election. The lower court panel unanimously, three judges said, yeah, Donald Trump doesn't have absolute immunity against prosecution. No president does. And they gave Donald Trump just 1 week to go to the Supreme Court and ask the Supreme Court to put a pause or a hold on his trial. And if he didn't do it within a week, then his case was going to begin moving toward trial again. So at the last minute, he filed the request for the stay or the pause. And then immediately, I mean, within 12 hours or so, the Supreme Court said, okay, prosecutor, special counsel Jack Smith, we want your reply to Donald Trump's request for a stay within 1 week. So we're going to see something in the coming days where Jack Smith inevitably files a reply saying, no need for a stay. Let's get this case back on the trial track.
Now, is it unusual from your vantage that the Supreme Court is moving so quickly? And as a follow up to that, does it portend a quick resolution on their part on this issue of immunity?
Yeah, it is unusual. Generally, it's a pretty staid affair when things are filed in the Supreme Court. There are normal deadlines for replies to be filed. I think the Supreme Court appreciates the urgency of the moment. I would go so far as to say the Supreme Court is stepping up the pace a bit by asking Jack Smith for a reply within a week. I do think the fact that they want this answer from Jack Smith so quickly is an indication that they're going to move quickly toward a decision. And I'm going to go out on a limb and say that decision is likely that this case does not need to be paused or stayed or stopped while there is further litigation, if any, on this presidential immunity issue. So keep our fingers crossed because, our ultimate goal is accountability and justice. We'll keep our fingers crossed that the Supreme Court pretty promptly denies the stay, puts it back in Judge Chutkan's hands. And the first thing Judge Chutkan will do, I predict, is call the parties in and say, okay, we need to pick a new trial date. And that one is going to be set in stone.
Now, you'd mentioned that this was moving quickly as far as the Supreme Court is concerned, and they gave Jack Smith just a week. Can Jack Smith respond even quicker than the deadline of next week to get this thing going even faster? Like, why not respond today so that we can move on to the next step?
Yeah, he can and he might. I even suspect he will. But here's the thing. So Donald Trump and his lawyers filed a 110-page brief. Now, mind you, they are just retreading the same failed arguments. When I say failed, they have failed repeatedly. They failed in the trial court to convince Judge Chutkan. They failed in the appellate court to even get one of the three judges to buy into their nonsense about absolute presidential immunity. So they really padded this Supreme Court request for a stay. They probably could have done it in a half a dozen pages. They put 110 pages before the court, probably hoping that it might bog things down and maybe slow Jack Smith down a little bit in his reply. But as you say, Brian, the Supreme Court gave Jack Smith a week, but I am not so sure Jack Smith is going to take a week. He will need to go through it. He will need to have the attorneys who are the appeals expert on his prosecution team look at it, draft a reply, make sure all the T's are crossed and the I's are dotted, all the footnotes and citations are accurate. But we could see a reply within 2, 3, 4 days.
Okay. Well, to that point, what are next steps here? Like, how many more procedural motions do we have to contend with before we actually get a decision on the meat of this issue?
Yeah, the next step might be the whole ball game. And here's why I say that. Once Jack Smith files his reply, which will undoubtedly be, we don't think you need to stay this case. We don't think you need to take review of the case at all. But that's not what is at issue right now. The only thing at issue in this new motion and reply is whether the Supreme Court should stop the case dead in its tracks or put it back on the trial track. Jack Smith undoubtedly will say, put it back on the trial track. If the Supreme Court agrees to put it back on the trial track, that is almost the whole ball game. Why do I say that? Because the law as it applies to immunity says nobody should have to do anything to defend themselves at trial or even prepare to defend themselves at trial if they in fact have immunity. Because if they have immunity, they shouldn't be prosecuted in the first place. So reading between the lines, if the Supreme Court says, we are not issuing a stay, we're going to let this thing get back in Judge Chutkan's hands, she can set a trial date, and the case can move in the direction of trial, that will be some really important foreshadowing that the Supreme Court has all but decided, no, we are not going to entertain this absolute immunity nonsense. And if we do entertain it, we're only going to entertain it so we can write an authoritative legal opinion shooting it down precisely the way Judge Chutkan did and the way the three-judge panel did unanimously. Sometimes the Supreme Court likes to feel like, the big dogs on the legal block. So they may say, you know what, we agree with all of those other judges who have already rejected Trump's claim of absolute immunity. But, for posterity and history, we want to be the ones who author the authoritative Supreme Court opinion saying so.
Glenn, just for posterity here, can you walk us through what we can expect in terms of the timeline? I know the main question that everyone's wondering right now is, could this thing still happen? Assuming that the Supreme Court rules correctly and says that Donald Trump doesn't have full immunity to do whatever he wants as president, assuming they rule that way, if we would still be on track based on where we are right now for a trial before the election?
We would be. And here's why I say that. Assuming the Supreme Court gets this right, and I think they will get it right, for goodness sakes, the Constitution says inferentially a president can be prosecuted. Not only that, a president can be prosecuted even if he's impeached for the same conduct and the same crime. There is no open question of law or of constitutional interpretation. So I am fairly confident the Supreme Court will get it right. And assuming the Supreme Court is prepared to say a president does not have immunity, he can be prosecuted for crimes committed while in office, I think they're going to say that much sooner rather than later. Because if that is their legal conclusion, I think they understand the urgency of the moment, the need to get this back on Judge Chutkan's calendar so she can set a trial date. If that happens in the coming weeks or even in the next month or two, I think we're going to see potentially a summer trial. And that will resolve the case well in advance of the November election.
Do you think it's possible that that based on where we are right now, that this could take the trial date of May 20th, which was supposed to be, or it's still pending to be the classified documents case, but I think there is an expectation that that case would be pushed back?
I think there is an outside possibility that they could substitute the DC prosecution for the Florida documents prosecution. As you say, Judge Cannon down in Florida set a May 20 trial date, and she has not yet canceled or postponed, or what we call vacated, that trial date. So I think that's a possibility. And it really boils down to how quickly can the Supreme Court put this back in Judge Chutkan's hands? Because Judge Chutkan had said, listen, when and if I get this case back, I will still give you some lead time, probably a couple of months, before we begin jury selection and we go to trial. So I think right now there's a possibility that May 20 could end up being the new DC trial date, or it could be, perhaps in June or maybe even July.
When this trial had initially fallen off, the DC prosecution, when this had initially fallen off trial track, we had about 90 days between that day and when the trial was supposed to take place. So if we had the same amount of days, that would put us roughly at around February 20th, February, March, April, May. So do you anticipate that that will need to be almost exactly the same, or is there a little bit of shortening that could happen if we're to see that May 20th trial date happen?
I would say a little bit of shortening could happen, but it's not likely to happen. Once a judge goes on record as saying, listen, whenever I get jurisdiction back, whenever they hand the case back to me, I'm going to give you about the same amount of lead time as you had before this delay, this pause, this hold was put in place. I think the judge will be loath to kind of back off that position and say, well, you know what? I'm going to cut it down to 60 days because I think the attorneys could rightfully complain that, look, Judge, all along we had this 90 days in the back of our minds because of what you told us. So I don't see Judge Chutkan really truncating or cutting down the time that she said she was prepared to give them.
All right. Well, to that point, hopefully Jack Smith and his team move quickly, at least in responding to this request by the Supreme Court. So, takeaway here, Glenn. Good news that the Supreme Court is already moving on this.
I'm going to say it's not bad news. I know that sounds like a cop-out. I would put it in the good news category, but probably only by about 51%. It's an indication that, one, the Supreme Court appreciates the urgency of the moment, and two, it could have been worse news because they want to reply quickly. That, to me, suggests that they're thinking more about a trial track than they're thinking about just getting rid of this case entirely because they are going to create out of whole cloth absolute presidential immunity from prosecution. I don't think they're going to do that. I think they know they're not going to do that. That's why I'm going to put this in the good news category.
All right, well, this is a game of inches, and we'll take every inch we can get. So with that said, we'll obviously stay on top of this as soon as we have any updates. For those watching, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.